Hello, my name is Michael Tesoro, and I prepared this video case note on the Takata Airbag class actions, which settled recently. And as you can see, it was a case taken against Toyota, Subaru, Honda, BMW, Nissan, and Mazda. Bit of background about myself: I'm a competition and consumer lawyer. I've been running my own practice, Tesoro Consulting, for the last 14 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as a Director of Enforcement. Out on the presentation, I'll start with the background to the case. We'll then look at the relevant considerations which the judge had to weigh up in order to sign off on the agreed settlement. Then I'll look at the decision of Justice Rees and finish with some commentary. Now, the relevant background is that this was 6 representative proceedings against the car manufacturers listed earlier, and there was actually a 7th representative proceeding that was split off. Now, in this particular 6 representative proceedings, there was 33,400 group members, and the primary allegation they made was that the defendants had failed to comply with their merchantable quality obligations under Section 74D of the Trade Practices Act, or the acceptable quality guarantee in Section 54 of the Australian Consumer Law. So as you can see, they've used the old legislation, Trade Practices Act, for some earlier claims, and then the current legislation for some newer claims. And effectively what was being alleged was that the cars which these companies sold to consumers were not of merchantable quality or acceptable quality because they contained or had a safety defect, namely a defective Takata Airbag. Now, the significant issue was that the Volkswagen representative proceeding was split off from the rest of them and actually went to trial. And in that case, the plaintiff was unsuccessful. And Stevenson found, after considering all the evidence, that the plaintiff had failed to establish liability. And he also concluded that even had he been wrong at that point and liability been established, he didn't believe the plaintiff had succeeded in showing that the consumers had suffered any loss. So that was Dwyer and Volkswagen Group Australia. Now, it's clear that that case had a very big impact on the decision of the plaintiffs to try and settle these current proceedings, because the cases were pretty much identical, and as a result, if the issues went against the plaintiffs in the Volkswagen case, it was likely they were going to go against them in this particular case. Now, having said that, Stevenson's judgment was appealed, and the appeal court has heard arguments in relation to it, and judgments have been reserved. But it seems pretty apparent that everybody concerned believes that this particular representative set of proceedings is likely to be unsuccessful if taken to trial. As some further background, the current case went to mediation, and it was mediated and a settlement was agreed at in relation to all of the representative proceedings, and a settlement sum of $52 million was agreed. And the case before Rees is about approving that settlement and the distribution of money to various parties. And the litigation fund in this particular case was Regency funding. Now, what was being sought approval for was legal costs of $16 million, which is a lot of legal costs, a funding commission to Regency of $13 million, which was basically a 25% commission on the settlement amount of $52 million, an administration fee of $2.5 million, and that's effectively to hire a company to take the settlement funds and distribute them to the class members. Then there was also a lead plaintiff fee. So there's 6 lead plaintiffs, and their role in the litigation is more than other class members. They have to spend a lot more time and energy in working on this particular case. So it's fairly common for these individuals to get paid more than the rest of the class members. So here it was proposed that each of those people be paid $20,000 each. So the total deductions were $31 million, and that is 61% of the settlement. Not 2/3 of the settlement as suggested by the judge, but still a big chunk of the settlement. And the implications of that for the payment were that if there hadn't been any deductions, that would have meant that each of the 33,400 group members would have got $1,558 per vehicle. However, after the deductions, that went down to $600 per vehicle. So as you can see, the amount that each class member was to receive per vehicle went down by about $1,000 once the deductions were taken into consideration. Now, the first issue the judge had to consider was objections from class members, and they fell into two categories. The first category was people who believed that the level of deductions were much too high, and as you can see, some of the words used to describe it were outrageously excessive, incredible, staggering. The third quote that she included there, a greedy cash grab by lawyers, etc. So there were a number of class members who thought that the deductions were simply too high, but it was only a very small proportion of the total number of class members. So ultimately, the judge didn't have to give it a whole lot of weight, given that it was such a small number of complaining people. The second category of people who complained were a strange category of who basically didn't believe they should get any compensation out of the class action at all, which seems a bit surprising that a class member would be actually arguing that they shouldn't recover any compensation whatsoever. Then the judge had to consider the two principles. Firstly, whether the settlement was reasonable between the plaintiffs and the defendants, and secondly, whether the settlement was fair and reasonable between the group members. So in relation to the first issue, she looked at the decision of Goldberg and Williams and FAI Home Insurance, and you can see there the factors that he's listed as relevant. Firstly, the amount offered to each group member, the prospects of success in the proceeding, the likelihood the group members will obtain more money if the case is run, the terms of any advice from counsel or independent experts, the likely duration and cost of the proceeding, and finally the attitude of the group members to the settlement, i.e. objections. So applying those criteria to this particular case, the judge concluded that the plaintiffs and defendants were both represented by highly competent legal representatives. The case was very hard fought. There were no settlement offers until the last moment when it went to mediation. And she was confident that the legal representatives would have provided their clients with an informed and sophisticated view of the strengths and weaknesses of their respective cases. So she believed that the settlement amount fairly represented the pros and cons of both the plaintiffs and defendants' legal positions. So she believed that the settlement amount was fair and reasonable. In relation to the strengths and weaknesses of the case, she did identify 4 issues which were going to loom large in any litigation. Firstly, the alleged propensity of the Takata airbags to explode, which depended on a number of variables such as the ambient temperature and humidity of the location where the vehicles were stored, the age and usage of the vehicle, also the modelling characteristics and the presence of desiccant. So all these factors would have had to be proven to establish liability, and that would have required quite a lot of evidence, particularly expert evidence, and the chances that that could have been established in relation to a large part of the class members was really not a foregone conclusion. In actual fact, it would be very hard to prove that in relation to each of the vehicles subject to the class. They also argued this defence point under 271 of the Australian Consumer Law, that basically their non-compliance was due to an act, default or admission of Takata. So the legislation provides that if a manufacturer does breach their obligations, then they can point to an act or default or admission of a third party. Now, that argument, I think, had some merit and would have been a big problem for the plaintiffs. The final issue related to the allegations of misleading, deceptive and unconscionable conduct, which is sort of the secondary case that the plaintiffs ran. And here the manufacturers argued they had a reasonable basis for making representations as to the safety of the vehicles because they relied on Takata, which was a specialist airbag manufacturer. I'm not too sure that was a super strong argument to make, mainly because misleading deceptive conduct provisions are pretty well strict liability provisions, so arguing you had a reasonable basis for representations I don't think would have helped them very much there. Probably would have helped them more in the unconscionable conduct case. But I think you're looking at those 4 arguments and you're seeing that the case was very shaky, and particularly in the light of Stevenson's judgment in the Volkswagen matter, there was a high probability the plaintiffs were going to lose. Now, the second question was whether the settlement amount was fair as between the group members, and here she's looking at issues of common sense and practicality. She's looking at the out-of-pocket expenses that each individual would have incurred due to the problems with the Takata Airbag, and she concludes that there wouldn't have been a lot of difference between the out-of-pocket expenses between different class members. So in that respect, she believes that a uniform payment to each of the class members is fair. It doesn't discriminate against particular parties who might have had slightly higher out-of-pocket expenses. It's also a very pragmatic part of this, because going through and trying to separately assess the out-of-pocket expenses of 33,400 group members would have been a very expensive process and would have been uneconomic, would have eaten up a lot of the settlement just in administration fees. So it made sense not to go down that path. So she believed that the settlement was fair between the group members. So the next issue you had to look at was whether the legal costs were appropriate, and she says there that I confess to having been initially taken aback by the size of the legal costs being claimed, $16 million, but she refers to some evidence put on by the plaintiff's solicitor which explained just how much there was in the proceedings, all the work that was done. There was a lot of interlocutory matters to be considered, and once she considered all those facts, she was satisfied that the legal costs were appropriate. That statement by the plaintiff's solicitor was declared to be confidential, so we can't see what he actually said, but we get a feel for it from reading the judgment. Then the next question the judge had to consider was firstly whether she had the power to make a common fund order and whether she should make a common fund order. And the funder sought an order pursuant to sections 173(1) and 2 of the Civil Procedure Act, but alternatively pursuant to the general law and in equitable jurisdiction of the court for a common fund order of 25% of the settlement sum, being $13 million. So she determined the first question in the affirmative, that she had the power based on authority to make a common fund order. Then when she went to the second question, she looked at the decision of Justice Ball and Smith and Australian Executor Trustees Limited, where he listed the considerations that should be looked at in determining whether to make a common fund order, whether the information provided to group members effectively was transparent, where there was clear information provided to class members, whether the funding commission reflects market rates, so clearly look at the amount being charged versus what's commonly charged in the industry, and if they're in sync, then that's going to support a common fund order. The litigation risks of providing funding, the quantum of adverse cost exposure, the legal costs expended, to be expended, and security costs, the amount of the settlement, and any substantial objections. So as I said earlier, there weren't substantial objections, so that obviously went in favour of the common fund order. So the judge, looking at all those particular issues, concluded that the funder had provided funding for 4.5 years, had assumed a significant amount of risk, had spent $18 million in legal costs, also had to provide security for costs of $8.43 million, and further, the adverse cost orders which it was facing would have been in excess of 31 million, which seems to me pretty light, really. I think it would have been higher than that. And so based on all those factors, she concluded that the funder had taken on a significant risk, and therefore the commission that it was seeking of 25% or $13 million was appropriate in the circumstances. There's a pretty compelling case for a common fund order, because if a funder takes on 6 large global car manufacturers who are represented by the top tier legal firms who are charging no doubt very high fees, then it's clear they're taking on an enormous financial risk, which if they're unsuccessful is going to probably bankrupt the litigation funder ultimately. So just having a bit of a look at the case, I think it's pretty clear that the plaintiffs were going to lose this case. There was a lot of issues identified in the Volkswagen case which made it likely that they were going to go down in this particular case. It was a very difficult case to prove that there was a causal link between the Takata airbags and the conduct of the manufacturers. The defence under 271 of the ACL seemed strong argument, and it would have been a very costly trial to run, particularly with all the expert evidence that would have been required and trying to come to expert opinions which would have covered a large proportion of the class. The deductions appear to be very, very high, but I think when you look in the case and you see just how much work was done, how many interlocutory proceedings there were, the size of the law firms on the other side, and I guess the cost assessors did look at the cost being sought by the lawyers and concluded that the case had been run by the plaintiffs by a small team in a very efficient manner. In actual fact, the cost assessors believed that the law firm should be entitled to higher legal costs than they were claiming. So I think looked in context, the deductions appeared high but were reasonable. I think the legal costs of the car manufacturers, had the case gone forward, would have been enormous. They threw so much at this particular case, particularly I guess the risk of having to pay refunds to consumers for motor vehicles would have been a big liability, and so had the case proceeded, it would have racked up millions and millions of dollars of legal fees. It is interesting that the Volkswagen appeal outcome has not come out yet, and I guess there's a small possibility that the appeal court will overturn Stevenson's decision, but I think that's quite unlikely. If his judgment is overturned, I think it's going to result in quite a lot of red faces and amongst the plaintiffs for having settled this particular set of representative proceedings. The final issue here is, I guess some people pointed to this case as an argument in favour of the class action reforms which the Morrison government put forward, and they included things like requiring that class funding organisations have a Australian Financial Services licence, that they be classified as managed investment schemes and provide product disclosure statements. And there were some further reforms which didn't get through Parliament, which would have actually provided a requirement that minimum returns be provided to class members, which really would have undermined the economic viability of running class actions. That didn't get through Parliament. And more recently, the Albanese government has sought to reverse all these so-called reforms, so removing the requirement for an AFSL, also removing or providing an exemption from the requirement to be a managed investment scheme and to provide product disclosure statements. So they've reversed all those Morrison changes. So it's unfortunate that class action reform is such a political football, and it does actually generate a lot of justice for consumers who otherwise would not be able to pursue claims. And so I think the direction that the Albanese government's going with the changes is the appropriate direction. So that's all I had. If you have any questions about this particular presentation, it's an interesting case, please feel free to give me a call or send me an email. Bye-bye.